So, he's still on the stand, and I said, well then, okay, we're in chapter 75, and I said, under chapter 75, I think it's 74, 73, 43 or something. I forget now. I didn't bring my notes about that, but it gives the definition of person and everything in corporations, you know. And I said, am I the same person in chapter 75? And he said, well, I'm not familiar with chapter 75. I said, he said, we don't look up the codes that way. And I said, well, I understand, but in the, I'm going to go by memory here. I said, in chapter 75, in section, I think it's 74 something or something, the definition of person. I said, used in this subchapter. Now we're in subchapter 75. So, I mean, and the code that you're after, that you stated that I violated a criminal statute. I don't know how you can violate a criminal statute, but in your opinion, I did, and it seems to be a secret. So, am I the same person? And he looks it up and he reads it and he goes, yes, I am. And I said, and how's that? And he said, well, you're the employee of it. And again, I didn't want to go into the argument of all the definitions. I said, with that being said, under chapter 75, which you're not familiar with, so we'll just say section 7201 for your easiness, Mr. Solar, can you tell me where Congress extended the authority of the Secretary of the United States pursuant to Title IV, Section 72? He said, well, I'm not familiar with that title. And I said, okay, then you must, do you remember when you and I first met in September of 2003? And he goes, yes. I said, do you remember me asking you for your delegation of authority? And he goes, yes, I do. And I said, do you remember your answer? And he goes, yes. And I said, what was your answer? He said, I'll have to look into that. And I said, are you still looking into that, or have you found it? And he said, we don't need delegation of authority. I said, you don't need delegation of authority? He said, no, it's by chain of command. It just goes down, you know. I said, does it go down in telephone communication, or is there paper communication? I mean, the secretary, you know that the secretary authorized you to come to my house without any written form of delegation of authority? That's when the U.S. attorney objected. He said he didn't need delegation of authority. And I said, well, you know, and she says, you know, to go on, you know. And I said, well, I object. And she said, so noted. And I said, no, I want to argue this because he needs delegation of authority, and I like to see it. I need it. And she said, move on, Mr. Chapman. He stated he doesn't need it. I said, okay. So I said, in the beginning, at the first part of the hearing, Chuck Consis, as you all know, is in jail, bless his heart, and I did a criminal complaint that he was putting out back in 2003, and I wrote it to this Judge Fawcett. I followed up 30 days later with another criminal complaint, copied her when I sent it to Perez over here in Tampa, the head of the U.S. attorney. Then I sent her another criminal complaint, copy of several months ago, and when I was in court on a motion to quash, wish I knew what I knew now when I did it, but I put this into the record. And this is a complaint that we'll be going over after lunch, and we're going to be on the phone call with Dave Maryland regarding this. But I said, Your Honor, before anything started, I said, wouldn't it be a little bit biased on your part to be hearing this, being that I've written you under Title 18, Section 4, of informing you that the very people in this courtroom that I filed a criminal complaint against them, and then naming you as being complicit because you didn't respond? And she goes, you can take that in another day. And I said, I will. Yeah, I will. And I am. Big time. These people got a lot of guts, you know? And that's the problem, is getting the enforcement. And I think in numbers we can get the enforcement. But one in the field is not a good thing. But anyhow, so we went on, and with David Solar, he didn't know, you know, bottom line, he didn't know what tax he was after me for. It's a secret, he can't tell me. And it's a personal income tax, which there is no such thing as personal income tax. If you do a search, personal income tax doesn't come up as a, you know, any bona fide heading like oil tax or, you know, or any form of an excise tax, which he stated on the record is not an excise tax. Well, if it's not a direct tax and it's not an indirect tax, it can't be any other tax. It's impossible. So they're coming up just out of nowhere, which is not hard for me to believe. So then after that, the judge ruled, you're gonna love this, the judge ruled on the end of the day at February 13th. It was about 11 o'clock when I left the courthouse. It was about 4 o'clock that afternoon that I got them to fax it to me. They first wouldn't fax it to me. And I said, well, the judge is going to write me an order. I need it in writing if I'm going to go to do the exemplars, because she ruled against me. And I get the fax. Up here, it says file, 2007, February 13th. At what time does it say?
5 a.m.
5 a.m. I was in court at 9 a.m.
On the same day?
On the same day. You think they wrote the order the same day?
I wrote it before you
You think the order was written before I got there? That's going to be interesting when I bring my criminal complaint to the Supreme Court. Okay? And that's where we're going. We're going right to the Supreme Court with this. I got so much criminal activity on these people, it's beyond. The only thing is, if I'm found on the side of the road with a bullet in my head, you probably know why. But here it is. Okay, and you know, and that's why they file and stock, you know, stamp it and everything, because that's the record. Okay, and they can't go back and change it now. The order. This is an interesting order. Now this judge, the guy, some of the people that are helping me with this said the judge did me a favor by pointing this out explicitly. Expressly. I like to use that word now. Expressly. But I don't know. I really don't know, because she's such a criminal. I mean, she is such a sleaze bag. I can't see that she did this intentionally. But here, now she's had this argument in 3 different ways. She claims she read my whole entire brief, and which was probably a total of 160 pages with exhibits and everything. She claims she read it because I filed it on the 12th. The next day was the 13th. And she made the order at 5 a.m. She was up early. And and this is her order. Title 4. The court will address the contentions in turn. On Title 4, Section 72, all office attached, and she restates the thing. Notice the court case she uses, that Hughes, this argument of Chapman is without merit. Now, when you go back and study the Hughes case again, it says that the president can make federal districts, but it doesn't say in the 50 states. Now, the federal district, would be like the customs, at the airport or the Port Canaveral. That's where, that's where they do a jurisdiction, it's customs. And the revenue agents are assumingly customs agents. I don't know that to be a fact, but that's what I hear, and I'm not sure. But so that's without merit. Again, this case has been used over and over again with the same terminology without merit, but they cannot make a decisive comment on that. Now, the term, okay, now Mr. Chapman argues that the IRS has no authority to personally tax him or to investigate him and reach, I just want to back up one step. She says here that Chapman argues the effect that the IRS has no authority outside of Washington, D.C. pursuant to the statute. That contention is without merit. I never said that. I never told her that the IRS had no authority outside of D.C. And I never said it, I never will say it, and it didn't happen. What I did say, that there wasn't any express language for them to operate in the 50 states. That Congress gave them the authority to exercise in Guam, Puerto Rico, Somalia, and all these other areas. Is that outside the district? Absolutely. Okay? So she lied. No, and that's another mistake, okay? That's another mistake, and I'm glad you brought that up. The question was, did I bring a court reporter? No, I didn't, and I always do. At every books and summons thing I've been to, or been with helping other people, even with the IRS agent coming to my house, I had a tape recorder. Where do I take that tape recorder? I run down to my local court reporter, and I said, transcribe this to me. And then I transcribe it, and I send a copy to the IRS agent to give him 10 days to rebut it, or it comes back. I got stacks of transcripts of every conversation I ever had with the IRS. Can that be used in a court of law? Absolutely. Okay, so, and relying on their tapes, now in this district, I don't know if it's the same in other districts. In this district, you are not allowed to bring any recording device in the courtroom with you. Can you imagine that? They ask you, do you have a tape recorder? Of course, you can't bring cell phones and everything, but said, do you have any tape recorder? I said, why? They said, you're not allowed to have it. I said, who said so? It's the rules. Who made the rules? The chief judge. I said, why? Because she doesn't want contrary records? And he said, well, I don't know, you just can't bring them in. I said, okay. So, but if I ever go to another hearing, I am bringing a court reporter. It's necessary because they can't refuse it. You just got to give them notice. If they refuse it, then that's an arguendo thing that you can hold off from going to court until that's answered in appeals court. Because you are entitled to your own record. And if you want to bring in a verified, not a verified, but a certified court reporter for your own personal transcript, you have a right to do so. But when she does it, she must send a copy to the court and let them rebut it if it's not true. And of course, they tape it, and she does the dictation, and so it's on the record, expressly on the record. Okay, so then we move on to Mr. Chapman argues that the IRS has no authority to personally tax him or investigate him, and that the reach of the IRS does not extend to conduct with the states. This argument is not well taken. All individuals of the United States are subject to the tax. Now, which United States is she talking about? Under the IRS code, the term United States person. See what she did? She's using 7701 against me. Includes citizen and residents of the United States, domestic partnership, corporation, states, trust, United States 77013. The term person under the code is construed to mean an individual. See, we went through that already, right? Not any individual, an individual. According to the code, every person liable for any tax imposed or the collection thereof must keep records and such statements and make returns to comply with. So then, she goes on. Wait, there's more. Yeah, 6011. Okay. Then, okay, this is a good one now. Now, this is enlightening. Lastly, Mr. Chapman argues that the court lacks jurisdiction over his case and also challenged whether the subpoena issued him was proper. The argument is without merit, of course. Mr. Chapman does not challenge, now this is the key thing here, Mr. Chapman does not challenge the fact that he is a resident of Brevard County. Now, I got a domicile that John Jennings, in the early stages, helped me produce. And I filed that back in, 2002, maybe, or something to that. And it says, I am not a U.S. person. I am not a resident. Okay? And it says all that. Now, if she's the master of her own ship, meaning the district, it's her duty to know who I am and to find out who I am. It's her duty to see in the public records if there's something there. And she took it upon herself just to go at 5 a.m. in the morning to go ahead and write this order. The United States Court, the Middle District of Florida, has jurisdiction over 35 of the 67 counties within the state of Florida, including but not limited to Brevard County. Now, do I live in Brevard County or at Brevard County? See, it's just like, Title 28, 1746, you got the laws of the United States. You got signing on the penalty of the perjury pursuant to the I forget the wording, but the United States, and then you got item number 2, you signed it under the laws of the United States of America. One has laws and the other one doesn't. See? So the same thing with the local jurisdiction. You got 2 jurisdictions. You have a cloud over Brevard County, which is federal, and then you have the de jure, the land, the solid soil, which is not there. Theirs is on paper, ours is, you kick the dirt. And so I didn't argue the fact, and I'm hard of hearing, so I didn't know, but I don't, recall them expressly saying that I was a resident. They might have said, he was a resident of Bar County, I might have missed it, so big deal. See, local rule, Mr. Chapman is a resident of Bar County, thus the Middle District of Florida has jurisdiction over Mr. Chapman and the grand jury convened in the district. A grand jury investigation commenced within the Middle District of Florida does not require an affidavit or permission to focus an investigation in order to conduct a business. I argued there that, under the criminal rules under the federal rules of criminal procedure, we kind of passed Rule 3, and just jumped to Rule 11 or whatever it is about a grand jury. Where does somebody make a complaint? Who is the damaged party? Who is the real party of interest? And when I asked this in the grand jury, before the grand jury, he said, well, the IRS. I said, well, the IRS is a fiction. It's a piece of paper. Who with signature an affidavit of probable cause that I committed a crime? Was it Solar? No, he's just investigating it. Is there somebody in this room can tell me who is the interested party? Is anybody here? No, ain't nobody answered. I said, and so in the courtroom, I tell the judge, I said, nobody is stepping up to the plate of a damaged party. Nobody's stepping up to the complaint that they signed an affidavit. So she's telling me, yeah, we don't need one, we can just ruin your life without it. And so finally, Mr. Chapman presented no evidence that the subpoena on him in this instant case was invalid. Well, I don't know. I guess she didn't read everything that I gave her, because all the evidence is right here. That, and this is explicit, and I'll leave this here. Don't take it away or anything like this. If somebody just wants to read through it. And we'll go in more detail after. So she ordered in conclusion that I am to give it up and do it, or I will go to jail. And she made that expressively. Said, you don't do it, you will go to jail. So on the 14th, I think we're going to take a break in 5 minutes for lunch. And, but I'll show you my domicile. I gave this on the 14th to show her that I hereby declare that pursuant to the foregoing, I am a Florida state citizen and not a citizen of the United States, or a U.S. citizen, and all rights of the undersigned are hereby reserved. And it shows my principal address and so forth. Now, if I was to do this today, I'd probably word it just a little bit different, but this is still awesome in effect. And I don't know if any of you know John Jennings, but he's an awesome guy. And in fact, one of his partners are here, and they're a great research team and just full of knowledge. And we'll break for lunch, but while we're breaking, I do want to thank there's so many people I can't name all of them, but Eddie Kane, Howard Friedman, the late John Fairburn, John Jennings, Mark Marlin, Joe Saladino, Dave Merlin, all these people, and there's so many more that have so much knowledge out there that it's up to us to to have these meetings, or even in the locale where I am, there's only 3 or 4 of us. But I bet you if I did an advertisement in the paper, who is happy with their government, please raise their hands and meet me at the table. I bet you know, nobody will show up, or very few. So I think that maybe something in the near future, and we'll talk about this after the break, about grassroots system and what we can do and how we can do it. But like I said, we're all individuals, for the private term. We're all individuals doing our own thing. We all have our families, our businesses, our work, our jobs, our hobbies, and in our lives, and we can't do it all. We can't do it all the time. But if we can do a little, and a lot does a little, we can get a lot done. Okay, I left the courtroom, right? Yeah. Okay, after I left the courtroom, the following day, I had to do the exemplars. But after getting the judge's order, which was on the 13th, I have a thing here called Showtime. I named the file Showtime because I was thinking of, what's that actor, Jim Carrey? Yeah, Jim Carrey, and where he has the mask and everything, and he goes, "Oh, Showtime," you know. And that's, I don't know why I thought of this, but I was up all night. Only got about 2 hours sleep, but I filed in response to Judge Fawcett's order. And Judge Fawcett's order, this goes on for 26 pages, and the guy from Texas helped me with this, because my other help was pretty busy and inundated with some other things, and we didn't really expect it to go this like this. But anyhow, we put a rebuttal into her order. Now, the next morning, I got this, you know, I got up, I went to bed like at 3:30. I got back up at 5, and I had, my wife has a computer with her printer, and I have my computer with my printer. I had both of them going, printing out all these documents, and I know I couldn't get to a copier place, but I had to be there by 9 o'clock, and so I couldn't even, and I live in Cocoa, the courthouse is in Orlando, and it takes me, with all the traffic and everything, about an hour to get there. And so I left right about 7:45, and I couldn't even get a notary. So I said, well, I don't need a notary, I'll just wait till I get to the courthouse, because, you know, they got clerks and lawyers and, you know, all kinds of notaries. Well, I get up there, and I want to fly, and I get in the elevator, and who joins me is Solar and Stairface. And so they said, you know, going up to the 5th floor, I said, well, drop me off at the 3rd. And he said, what, are you refusing to do the exemplars? I said, no, you know me, I never refuse. I just want to file this into the clerk. I'm asking for a hearing. And, you know, I still do have my rights, you know, whether you want to walk over them or not. And he says, well, he said, you better be up there at 9. And I said, don't tell me what I better do. So I walked out of the elevator, and then I went to the clerk's office. I said, I need a notary. I need to get this filed today. And she said, well, we can't notarize it here. And I said, what do you mean you can't notarize it here? She said, well, we can't provide that service. I said, it's my signature. I want to notarize it. I didn't tell her I didn't have my driver's license on me. They almost didn't let me into the courthouse because I didn't have my photograph, my driver's license. And, you know, because, you know, when you walk into the courthouse, you got to show your, you know, identification. And they said, well, you can't come in. I said, that's great. I said, thanks a lot. Will you go ahead and tell Fawcett that you won't let me in and I'll leave? And they said, well, wait a minute, what are you here for? I said, never mind, you won't let me in. What do you care? And they said, no, come back here. And I said, well, what do you want? He said, what are you here for? As a grand jury, you know, I got to do exemplars. Oh, well, come on in. I said, I don't have my ID. Well, come on in. So, but next time, bring your ID. I said, I don't think so. So so when I got up there, they wouldn't take my signature, and you know, and I had documents I wanted signed and everything. So then I had my wife, and my wife is, you know, she listens to everything that, you know, she listens to me on the phone. You can't ask her anything about, you know, what I do or what I'm doing, because she gets confused because I talk to so many people about different things. And all she knows is, you know, she prays for the government, she prays for President Bush. We pray for President Bush in different ways, you know. But she's constantly in prayer about it, and bless her heart, I think that, of course, our government does need prayer, but I think we need it more than they do. But she wrote it, and I told her, I said, look, they won't let me file, they won't let me get a thing to file, so I need you to get this to the clerk of office and tell them that I need an emergency hearing. So she gives me this, she knocks on the door when I'm ready to do the exemplars. The attorney didn't want to let her in. And she says, my husband says I gotta file this, I need a signature. So he let her in. And so I signed it, and I really, you know, when you're under the stress and under the gun, and as tired as I wasn't thinking. So I signed it, but I wrote up here petitioner. The reason I wrote it as a petitioner, because I'm not a defendant. I'm a federal witness and an injured party. Okay, so so I crossed out the plaintiff and put the petitioner, and because I'm not even a plaintiff at this point in time. I'm just witnessing the crime. And she writes in here, emergency motion to see Honorable Judge Fawcett. Sorry it's spelled wrong. And I said, you didn't need to apologize. That's what she is a running faucet. Upon receiving an order from the court last night, there are many things that are not true stated. I am ordered to give exemplars or go to jail, and I will give exemplars after I can say what's not true in your order or in this order. The judge writes back, I don't understand what it says there, but basically denied and provide the exemplars. So, and I figured that was going to happen, but it was at least a good try. And so what I wanted to get in there was the, and argue that her order, one on the United States person, that, you know, the domicile was in the, excuse me, my domicile was in the, in this rebuttal.
When you filed that day?
I filed it the same day I did the exemplars on the 14th. And the, better this way.
What is an exemplar?
Exemplar is examples, okay? That's basically what it is. They want handwriting exemplars, and I'll go through that for the people who don't know, because it's really
Your name without register?
kind of a pain in the neck. But, oh, you know what I wanted to make a real good point and an arguendo about is, let me see, Fawcett's order. I want to, you know how everybody discussed the name in all caps? opposed to the way you write your name. And for many years, you know, I said, well, you know, how much meat is that, or so forth, because although we can't find anything that makes claim, we're making a presumption, which is a very, very, very strong presumption. I mean, the only time you ever see your name in all caps is on corporations or the tombstone, okay? And being that I'm a walking, living, breathing man, they must consider that I'm some type of fiduciary or a corporation. Well, in this order, you see how she names me right here, you know, Christopher Rhodes Chapman, in uppercase and lowercase and everything. But there, when she writes the order, of what this fool ought to be doing, based on the foregoing, the court finds that, in all caps, Christopher Rhodes Chapman. I find that interesting, just for the sake that there it is, you know? She's coming to me as the flesh and blood, but she's ordering the fiction. Now, exactly how I deal with that, I don't know just yet. I got some good ideas, but I forgot to bring that out earlier. But the showtime here is what I got down to a judicial notice here, talking about the fraud that the court is doing. And I'm not holding back any punches. I'm doing all that I can to make the judge know, and soon 80 members of Congress are going to have this, along, you know, the follow-up with my complaint. The Supreme Court's going to have the complaint. I'm sending it to the Federal Bureau of Investigation. I'm doing all that I can to let everybody know. You know, it's like that movie, The Alamo, when Davy Crockett's going to get, guys are going to spear him. He says, you know, just want to let you know I'm a screamer. And that's what I'm doing. I'm letting everybody know from that has an office. And I think that what I like to do locally, as well as you all do in your local areas, you need to team up with 3, 4, 5, 15, 25, 30 people and start seeing your representatives. And with this letter that I have on the disc about Title IV, Section 72, you know, because my first question, if I was to go up to a legislative branch, I would say, Bob, are we still in a representative form of government?
Dang, I know.
Well, I mean but you see, and that's probably what the legislator would say. But over in mine is David Weldon, okay? And he is a no-sense doctor, but we need to go up and start going to the legislatures, even the county commissioners. We need to know, we need them to know that the people are getting tired of this. It's getting old. We need to start going to every commissioner's meeting on the local level. Mr. Commissioner, have you taken an oath of office to support and defend the Constitution? Are you there to protect our rights, or are you there to, act in criminal capacity? You know, which is it? It can't be both ways. And start taking issue. In this on the 14th, I've also asked for a discovery, because now I want to know, did the grand jury, for this court to go this far, did the grand jury get the questions that I asked them? Did they get the evidence, and were they allowed to actually discuss the evidence? I have a right to confront my confusers. I have a right to confront my confusers, because they confuse everything. Accusers. And I should be able, even in front of the grand jury, to discuss the criminal charges that somebody says that I violated. And so, I'm not getting any response, which is kind of a good thing in one way, but kind of a bad in another way. So I got to now compel the court to move on this petition for discovery. Now this is the exhibits. And the court has yet to rule on this, on my rebuttal. But anyhow, so that's that. Then I say you saw my, this is the non pro tunc. This is what I use to rebut and rescind all my signatures on any forms that I sign with any government, including and not limited to my driver's license and so forth. Now, am I giving my driver's license back? No, that would be committing suicide as far as I figure. But it's not my driver's license, it's theirs. I'm just rebutting my signature on there. Eddie Kane's wife the other day, a couple of weeks ago, went to one driver's license place and she signed the license with reservation of all rights. And the lady said, you can't do that here. If you want to do that, you're going to have to go to the state office. So she said, okay. So she went to the other driver's office. I didn't know they had different type of office for driver's license. And so she signed a driver's license. She says, you know, all rights reserved. And the girl at the counter says, you go, girl. And so she got her driver's license. So about 2 weeks later, it was about 4 or 5 days ago, she calls me and says, you know, I just got a letter from the Department of Motor Vehicles. They're rescinding my driver's license as of 20 days because they say I can't sign with all rights reserved. Now, since she's been back from Panama, she opened a bank account at American Bank. A week later, they closed it. She's with no reason other than the fact that, you know, we don't think that you should have an account here. So I think there is really a conspiracy theory here that they're really conspiring to make her life miserable. And
when at this American Bank, did she sign her papers, all rights reserved? Is that why they closed it? In other words, the closing of the bank account, do you think had something to do with the driver's license?
I don't know. All I know is that the different agencies, whether state or federal, are making her life miserable. So anyhow, I did a non pro tunc to rescind all the signatures on my 1040, like I said earlier. Then I have a copyright notice has been on file since 2003 at 9 a.m. in the morning, and so they use my name. They can pay me. Enforcement is the problem that I find, but you know, we'll keep at it. Then the emergency notice, okay. Objection to the court. Let's see. Okay, this is the objection to the court order, and where I disputed a lot of the her claims that, you know, I'm a U.S. person and all that, and yeah, that was part of my, and again, this is all on the disc. Now, the This you can find on your desk, but as well as the Freedom Committee, Freedom and Privacy Committee.com. This is, I believe, is a lawyer that wrote this mandamus, and it's a very good one. It talks about taxpayer means fiduciary. And when you go through this, of course, he touches Title 4, Section 72, I believe, but he goes on to how the U.S. district courts are not U.S. district courts, and that they're, territorial courts. And he says it in here a couple, that's where I got the expression, I'm not in France, because of this mandamus. And it's very well written, and it's very on point. I'm not sure where it's at right now. I've been wanting to follow up on it, but like everything else, is due to lack of time. But here it says taxpayer means fiduciary. So long there is even one published opinion to the contrary, the people of anti-notice. The anti-notice renders mens rea legally impossible to prove as a matter of law. There is no point in any investigation by anyone of any tax matters as a matter of law. And I say this stuff here, if you go ahead and print it out, that's what I do. I got probably, I stacked them, they'll probably be this high. I put them in a reamer, or if they're real big, I take them to Staples, and I sit, I have them in the bathroom or something, and when I'm sitting there, I can read them, and I'll mark the last page where I read, and it may take me a month just to get through 30 pages, but eventually I do get it, and what I don't understand, I don't go to the next page until I understand it. And in fact, unfortunately, because of this, all this criminal activity, I can't even hardly walk in my house anymore. I got books and pamphlets all over the place.
The Constitution authorizes the federal government to have two taxes, a direct and an indirect. Indirect is better known as excise. The income tax, when it was originally written, was supposed to be an excise tax. That's been retrieved from congressional records. It was acknowledged as such within the congressional records. However, the tax moved from being an excise, because an excise has a restriction on it. It must be uniform. It has to be the same, whether it's the 3% long distance tax or it's a 20% on washing machines or airline tickets. In all of several states, it has to be uniform. So someplace around 1937-38, some shrewd young lawyer out in Chicago probably said, we're in trouble. We're starting to manipulate the public. We're going to take from some and give to others. This tax no longer can qualify as an excise tax as demanded by the U.S. Constitution. It must, in fact, be repealed. So it was repealed so Congress could do many other things with the tax. In its repealing, it has never, ever been reinstated. It's been appended, amended, added to, deleted from, changed from time to time. It has never been reinstated. It is still there, though, as Title 26, not as positive law or not even as non-positive law. It's there as an invisible contract. And that's the reason we still have it any place in the book.
Now, the letter to Congress, here you have a letter to Congress to your representatives regarding Title 4, Section 72. And here you are asking questions. Now, this is one of the things that you can do to show, if you even think about, plan ahead. If you haven't even started not having problems with the IRS, well, don't wait till you have problems. Start today. Start writing your congressman regarding Title 4, Section 72. and do other things to protect yourself, because at any time, they may want to claim that you've been willful, and you're, no, well, okay, go ahead, Mark.
Now, I'm sure that there are more than one for the entire metropolitan area, so I'd like to know which one is the one for the southeastern water for the Orlando metropolitan area.
What, the representative?
Yes.
Look in your phone book, your yellow pages is listed there.
Okay.
Okay. Well, and also I may have a list, I may have something here for you. There you go, it's on your disc right there, okay? So when you get your disc, it'll be right there for you, even in Alaska. Okay, now this is what I wanted to show you here. This is a recipe for to know the qualifications and for your qualifications and oath of office and asking for their bond. And I'll be back in a minute. Stay tuned. I wanted to make an announcement on the Federalist Papers that you have. The encouragement is to print it out, make copies, sufficient copies to give it to school teachers, and other educators, get it through the churches, and so where people can learn it and study it, and of course, it's always better to have people in a group that have like-minded and get some kind of I don't know the word, esteem, get it going, so.
It's important to know that it contains additional Federalist papers that are new, and the old ones are written in modern language so that children can understand it, school kids can understand.
Oh, so yeah, it's written in modern language, opposed to the old language, and you say there's new things in there, which they don't even know the old things. So, but anyhow, it's educational, and of course, read it, the Constitution and the Declaration of Independence, and don't forget the Bible. Okay, this here, it starts off with Jack and Margie's presumption. This letter is lawful notification to you pursuant to the national constitution and the constitution of your state, which I guess everybody here lives in Florida. And of course, if they keep their mouth shut and they don't speak and answer, then they're liars and no good son of a guns. Okay, and under Ryder versus the U.S., we talk about the challenge position. And what it's asking for is their oath of office, their qualifications, and their bond. Now, why is that important? Well, if I'm driving or traveling, however you want to look at it, in a vehicle, and I run into you, whether I backed up into your car in the parking lot or something and just made a small dent and nobody's injured, well, we got two ways to settle it. We can call a cop and make a long, accident report and go through the, the proceedings, or we can exchange information where you can call your insurance company and they'll call my insurance company and file the claim and they'll pay it. Well, the same thing here in this issue is that when they go to do an election, but prior to the election, they got to fill out their qualifications. And one of them is their oath of office. And they have to have a bond. Now in Florida, from the research that I did a couple years ago, because I'm wanting to go after my clerk of court for not handling my notice of federal tax lien properly, I said, where's your bond? And he refused to ask. So I went to, what was it, crisis management or something like that in the county. And they have what they call blanket insurance, you know, like Florida's something, you know, where all the counties collectively make a deal, you know, where they're all insured. It's not really a proper bond.
Risk management.
I'm sorry? Risk management, yeah. It's a crisis when you get there. The risk management, and so what happens is that when, you know, an officer, whether or a public official, takes an oath to uphold, support, and defend the Constitution. Now, we've let that go so lightly, they don't even sign the form properly anymore, and, you know, and so forth and so on. But it's still the fact that they by taking the office to represent or to be the public servant, they are still under the guidelines of the support and defend and protect our rights that are secured by the Constitution. And it's inalienable rights that is described in the Declaration of Independence. I think, honestly, I don't know if other people agree, I think the Declaration of Independence has more substance than the Constitution does, because that's the birth certificate of our nation. And the Constitution is just more of a contract. But being with that said, then if he doesn't respond within 20 days, now this claims to call a mandamus, the action. And quite truthfully, I don't know, again, because of enforcement problems with our courts and other public officials, don't know how far we can go with that. But on the other hand, we can do a, you know, administrative remedy, you know, through a tacit procuration and so forth. So we're looking further to go in that. But what we're hearing, though, through some people that have used this, lawyers have literally got on the phone and begged to get off, to get out. And because if I, like going back, I got off track here, but like going back and hitting your car and the payment, they pay it, same thing when they infringe on our rights. When they infringe on our rights, they've done the damage. Now you put a claim in to the insurance company, to the bond company. And a precipice means an order to do something. Precipice, I was commonly using it as ordering the court to do a certain filing or ordering the court to do a certain thing, or the clerk of court. But a precipice is one of the great writs. And I'm not going to name the great writs, all of them, but pro quo warranto is one of them. The habeas corpus is another. Well, the precipice is one of them. And it goes back centuries. So it's a pretty strong document. And it follows, you know, here it says, see the Administrative Procedure Act for deadlines and the alternative. And it goes, and then at the bottom of it, it talks about demand for certificate of copy of official bonds. You're asking if they refuse, then they admit to stepping outside their office. And under Title V, USC 552, you're giving them 20 days. And then you're giving them the law right there. I mean, you're doing them a favor. They don't even have to go and look it up. You know, you're giving it all to them right there. And this is supposed to be one strong document. Now, I sent this to Mr. Gold, the U.S. attorney that initially started the process upon me, to Blockhead, and to another one. Solar. No, I don't.
Are you making positive statements in there that you are
No, well, yeah, it's a, well, like for instance here, the constitutional oath of office is, see, we're getting down here. You hereby respectfully ordered and commanded by the great writ of precipice to perform a lawful function which your office requires you to do so, or to do, and is simultaneously required by your oath to uphold the Constitution of the United States for America and the Constitution of the State of Florida, which makes it a crime for a public official to be in the dereliction of his duty and is interfered with the civil rights of the people of the several states. Failure to obey this great writ of precipice may cause you to vacate your office. See, if they're a public servant, they got to produce that oath of office, or they vacated it. So, and what I'm going to do in my particular situation is I'm going to default them. And I'm going to give them 3 days to cure, and if they don't, then I want to enter that into the records. Not have they also done the other crimes that they've done. Now they've vacated their office. And so this court definitely has no standing. And also I want to look into the, where I say here the precipice is made as a for filing a great writ of mandamus to compel your performance. And I may try that in the court and just see where it goes, because it won't cost me to file anything. But knowing Judge Fawcett, I don't think I'm going to get anywhere, but I got to get her to recuse herself. That's the first thing I got to do, because I got to get rid of that animal.
If you call her as a witness in another criminal action or any civil action, she cannot be involved.
Well, she's going to be a defendant. I'm naming her as a defendant. So, and I will be going after her as much as I can. Now, remedy in the law.
Why don't you get rid of the whole court?
I beg your pardon?
Why don't you get rid of the whole court? If the jurisdiction, the exclusive jurisdiction over the tax assessment is in the state court, you can move the case and the parties to the state court by a writ of habeas corpus cum causa.
I'll be contacting you.
Yeah.
I mean, that's something, I know it's coming up and it's here, but I don't know about it yet. So it does sound very interesting.
I need to know.
Any way that I can get rid of it, that's what I want to do. Your remedy is in the law.com. Is here. A lot of you know Edward Michael, I believe. He was promoting Richard Cornforth a while back, and now he's doing this. And I told him that I would give his. He's kind of competing against me, but I'm not in a competitive mode when it comes to our liberties. Your remedy is in the law.com. You become a joiner. And the joiner is, the complaint's already been written. It's been served on 80 members of Congress and the, as well as the Everson and so forth. And it goes through the different crimes that have been committed by the officers as far as the offense by officers and employees. It goes through the Title 18 in detail, conspiracy to deprivation of rights on several different accounts on that, prohibited activities, false declarations before a grand jury in a court. That's what's happening with me right now. They're giving false declarations and false evidence. Mail threatening communications. They have, and the list goes on. And then on page, it breaks it down into several different issues. And issues being issue A, it has several questions where it makes statements like 3121E, an individual is a citizen of the Commonwealth of Puerto Rico, but not otherwise a citizen of the United States, shall be considered as a citizen of the United States. And CFR 31.3121E-1B, the term citizen of the United States includes a citizen of the Commonwealth of Puerto Rico. And this complaint also goes heavy into Title IV, Section 72. And it goes into the property of 83, and many pages in detail explanation on basically what you have on your disc, but in a lot more detail. And
What's the purpose of that suit, though? What are you trying to get?
well, the purpose of the suit is, well, first of all, it's not a suit, it's a complaint, it's a criminal complaint. And you're complaining to the legislatures because they're the ones that are making the law. And if they're making the law for the executive branch to enforce, you know, the law is actually perfect. If they kept the IRS code, would anybody here have a problem with it?
Yeah, it sucks.
Why?
Because it's hard to understand. Totally.
But given that it's hard to understand, the reason it's hard to understand is because they manipulated it to be hard to understand it. But a lot today, we do understand it, don't we? We know what a person is.
There's massive disagreement as to what it means. The people in the IRS repeatedly claim that it's a direct tax and it's totally lawful.
Well,
Totally constitutional.
is that the code or is that the people?
Well, that's the.
Okay, see, what I'm getting at, Bob,
The enforcers say
Bob, what I'm getting at is that the code, the law is actually perfect. Of course, it could be written more clear, that's a given. But the thing of it is that the enforcers, the executive branch, was to enforce the law as it is written, we wouldn't have a problem. The people in Puerto Rico, Guam, Somalia, and the other parts of the country or the world would be the ones having the problem. But it wouldn't be the people in the 50 states if they would go back to Title IV, Section 72. And so, and read Section 83. 83 is very much overlooked. And and again, like I said, there's 44, so far 44 U.S. attorneys have not been able to dispute it. And I have one attorney that I know he says, you know, it's right on point. So, but he doesn't want anything to do with it.
If you pose it as an admissions for discovery with admissions,
Oh, absolutely.
it has to be
Yeah,
assumed admitted.
right. It has been opposed as admissions and undisputed.
Mr. Cornforth mentioned the Doomsday document in Sacramento, California, when he was hosting the seminar.
I don't know the doomsday. Does anybody know what that means? Go ahead, Mark.
Similar document to the IRS.
This was a case that the IRS brought against somebody in California. I believe it's the Eastern District. And they brought their complaint to the district court in order to enforce an IRS summons. Well, they were doing it correctly. The only thing is, when this individual that received the complaint, he answered it. And anything that wasn't relevant, he simply pointed out that isn't relevant. down through the different elements of the complaint. When he got done, then now he has reciprocal discovery. So he sent all kinds of statements under, it was similar to the things that, that the Flynn's are using in order to determine their authority. And he started out by simple stuff, and then he got to where he said, now aren't you, no, you are committing, you are involved in racketeering with the IRS against the American people. And then he went on, all of the United States attorneys are in a racketeering scheme against the American people. And then he went to the judges, and all of the federal judges are involved in a racketeering scheme against the American people. And when he got done with sending that letter, he waited for the response, and they didn't respond. Now it's established by these opening and closing paragraphs
I thought I brought that.
all of these things that they failed to respond on are now established as facts, and they're chiseled in concrete now, or chiseled in stones. They can't change it now. There isn't any, by using that case, which is the number of the case, I believe, is 2:06-CV-0183, and you need docket numbers 70 through 76. If you can get the court to certify those to you, you can use that to establish the fact, the material facts that have already been determined and admitted to by a United States attorney that
I thought I brought
the
those docs
whole
with me, but I guess I
federal
didn't.
system are involved in racketeering.
What is the docket number again, please?
Marlon, I have uploaded those documents to my website.
Who has certified copies? Does
No,
anybody?
nobody that I know of.
We have to get a set of certified copies once, okay, well, you can get the docket too. Okay, well, he says that you need a certified copy of the docket, which, yeah, that's correct. So that's right, the certified copy of the docket shows, establishes that they have not made a response, that's correct. So once you get the proper certified documents, then that can all be in a whole set, that once you have it certified to you, you can certify that docket to anyone else. Because a certified document that is also certified, recertified, it's still the same as that certified one, which is also the same as the originals. So that's really what developed in that one case. So they just happen to have the presence of mind to know how to address that issue. And it's potent. It's going to be about as potent as the Schultz case, where he allegedly lost. Actually, it was a big win if everybody understands how to apply the Schultz case. Which one is that? Yeah, I'm not sure on the dates of those. That's a recent case.
What's that?
No, whatever it was, their
5:50. Yeah.
response,
Federal personnel means
Oh, yeah, they've been in default for a
Right.
period of
They were
time.
entitled to use any return. You're a federal employee. It's one of the invisible contracts. I don't know if
Thank
you've
you.
ever seen this. It's over in the administrative sections.
Yeah.
That they declared unconstitutionally, but they'll never put it into court because then you can in fact attack it. But that judge is proceeding against you under court. This is
Right.
what gives him the authority, or at least a feeling of moral authority. You were illegally
Oh,
unlawful.
this is the one I have, isn't it? Yeah,
Yeah, it is.
yeah.
It's in there.
Rich brought to my attention here in his book, Invisible Contracts. On page 57, Title 5, Part 1, Chapter 5, Subchapter 2, Section 552A, the definitions, it says the term federal personnel means officers and employees of the government of the United States, members of the uniformed service, including members of the reserve components, individuals entitled to receive immediate or deferred retirement benefits under any retirement program of the government of the United States. And what is Social Security? It's a benefit program.
You were all government employees by an unlawful, unconstitutional declaration of the government.
Right.
But they'll never announce it in a court, because if it was announced in a court, then you could have it in a record, go up on appeals, and it would be declared unconstitutional. Meanwhile, that judge, under color of law, ignores all of your arguments because he looks at you as though you were a federal employee.
Now, I guess, and you tell me if I'm wrong, this document here that I got, an affidavit of sham proceedings of promoting counterfeit securities, where I got 14 members of the party that we're having a party with. I did a presumption part of the letter, and I'm listing, several, many different things that they've done, and with no response, I'm going to do a default, and then put it into the record as a default.
Are you going through a notary public?
Yes.
Okay, good. However, all of those names that you have there aren't that necessary. It doesn't hurt.
Yeah. Well, it's all the ones, I'm naming all the ones that have injured me, that have falsely accused me, that has falsely and are involved in, especially Judge Fawcett, who I've sent 3 different complaints to her about these people, and became complicitary to the crimes because she hasn't done anything. In fact, she's sitting there judging it now.
You got a problem. Once you destroy that court, where are you going to bring the issues?
Court of Claims?
Bring them back to the state.
Back to the state? Yeah.
Can you repeat this on the microphone? We can't hear.
Okay, here.
The place to bring your issues now will be back to the state court, because it's the state circuit court that you have access to for redress of injury.
Ah,
See? So you want to use the court that can give you the redress.
okay. And it shall be done. First thing Monday morning, the letters will start getting together and going out. Okay, we're going to be soon wrapping it up here. I think I got a gentleman I'd like to have come up in a minute and talk about the administrative process. Yeah, basically. And there's a friend of mine from Cocoa. He's very knowledgeable on it, and then I don't know if we want to. I'd like to do a little session of what do I call it, role playing, and I don't know if we want to do that on the DVD or just do it as a extraordinary thing. If somebody wants to go home, that'd be fine. That's up to you. I would like to say this, that depending on your participation here, there's a lot of information I'm hoping that you think was given well, and I know we went through a lot of it, but that's why I put it on DVD or CDs for you. And if you didn't get it, of course, you can email it, and I can send it to you, or Bob Hurt. I'll send it to Bob Hurt, and he can e-snap it or whatever it is, and then send it to you. But go ahead, Bob.
I have one announcement to make.
Okay, and then, but I hope that you support the camera crew in buying the DVD because it's information. Like every seminar I go to, I always buy the DVDs because, you know, you watch it again, and as many times as you watch it, you always pick up something that you didn't understand or didn't catch before. And and it helps support them, which is supporting the group, because at every DVD package is sold, $10 goes back to the lawman group, and we need the funds. And with that being said,
Chris, what's your email? Will you go through a summary of what you have covered? Just a quick
well,
summary.
basically, he wants to know if I'll go through a summary of what I went through. I guess the part is, what part of Title IV, Section 72 you don't understand? That's basically the summary. The summary is, you can know as much as the laws that you want. You can know all the IRS codes. I spent years studying and going to seminars all over the country. I spent thousands of dollars on educational material, books and recordings, videotapes, buying, you know, information and so forth. There's, in my thing, if I, you know, knowing what I know now, that's always been the case, right? Knowing what I know now, Title IV, Section 72 and Section 83 is really all I feel all I need to know, outside of the court procedures and everything. But I don't think, if I did this back years ago, Title IV, Section 72 and Section 83, I don't think I'd be where I am today. I don't think there would have ever been a grand jury hearing. I don't think that there would have been any controversy to talk about. And I could be wrong. I don't know. None of us know. But the information with Title IV, Section 72 gives me the authority, it gives me the standing to turn the tables on them and saying, being that you cannot provide your authority from Congress where there's any laws that have been written to come to me in Florida. I'm not in Guam, I'm not in Puerto Rico, I'm not in anywhere, I'm not an employee of the federal government, and I've rescinded my Social Security and all that. I've gotten back out of that. That was a mistake getting back into that, and that's one of the downsides to Pete Hendrickson's thing. You got to use your Social Security number. Well, you got to look at the whole bundle. You know, you just can't say, oh, this is good, man, because, you know, they put an affidavit in that they paid me income, and now I can go back and say, well, I didn't make income and gross income and put zeros in there, but you had to put your Social Security number on there. And that Social Security number is a contract. Yes?
You said you got out of your Social Security number in 2008 when you have to get your new driver's license. What are you going to do?
I don't have a Social Security number. Show me the law that requires me to have a Social Security number.
They won't issue you a license?
Well, then great, then I'll travel by right. I mean, I don't have a choice then. Because they can't make you do something that you lawfully don't have to do. And Aaron Russo made a good point. When that card comes, what are you going to do? We're all going to, it's just a time of when we come to the point of taking the number, what we're going to do. You know, and that's why this, you know, this is very important that Congress has been doing. The executives are slowly encroaching, which they're not slowly encroaching anymore. They're here. They're in our doors, they're in our garbage, they're everywhere. They're coming up through the toilets. They're everything. Do you know that on Fox News, it said that if your cell phone is even in the off position, they can listen to you? Do you realize that? I mean, you know, do you know these, you know, we learned from what, Laszlo's thing that on these new TVs, I forget the nomenclature for them, but they can listen to you? I mean, you know, this is getting totally ridiculous. Can't wait till Jesus gets back. Hello?
The advertising market is into this too big time with this identifying chip in the car. They don't want to know if you're healthy or what. They want to track you every second.
Yeah, and that's it. So do we kind of agree we don't need to role play on the DVDs or anything, right? I mean, what do you guys think? No? Yeah? You want to, yeah? Is everybody going to get a DVD? I mean, is it going to be worth the time for the production crew to do it? Well, let's not throw all your hands up. Okay, Bob wants to make a statement, and RJ I'd like to have come up. With Bob first, and then RJ.
So folks, what do you think so far? Well, we have an ongoing program of education in this area for people who really don't want to be abused by government, but would prefer to reverse the role.
Okay, thanks.
So our friend and author, Frank Kowalik, who wrote the book IRS Humbug, after spending a few years in federal prison, is going to come down here in the middle of next month for a bang-up seminar on his principles by which you can beat the IRS with the law. And I will be announcing it. I'm just giving you a forewarning now for alert. We're going to do a seminar here in this area, probably over in Tampa, here, somewhere nearby, maybe in this room. And we're also going to do one down in Fort Lauderdale, because he happens to spend a lot of time living in that area, and maybe he knows some people that he wants to talk to. So, I encourage you to keep your calendar clear for somewhere close to the middle of April, if you're interested in getting some good information on how to tangle with the IRS and win further. All in the interest of improving our education. Okay, RJ?
Thanks. My name is R.J. McKee. I drove over from Cocoa with Chris, and we had a discussion on the way over, and I agreed to put in my 2 cents on something that's, I think, really important if you decide you actually want to fight the IRS or a debt collector or a bank or a court or a judge and have any expectation of actually overcoming or winning. I've been working with people for the past, roughly 11 years in helping them to gain resolution over debt issues and IRS issues. And over that period of time, I've noticed something very interesting. I've noticed that the winners, and these are people who either got dismissals or outright wins, all share the same common traits. And the losers, that is to say, the people who just gave up, also seem to share the same common traits. And I wouldn't even bring this up except for the fact that in the next few years, those who do not share the traits that I'm going to be going into will not only be losers, they'll probably be either in prison or dead. And that calls to mind what Patrick said about people who had to make a choice back in the revolutionary times whether they were going to be free, give me liberty, or give me death. And that is this. Everyone who won was pissed. Pissed to the point that they were completely 100%
100% committed to making something happen. And I just want to point out one thing about that that's very interesting. Most of these people went through a transition. Before they were pissed, they were afraid. And I got news for you. If you're afraid, you're going to lose. Because as long as they have leverage over you, which is the fear, you've already lost. Second point, the courts are not really courts. The judges are not really judges. They're actors in black robes. There you go. So the point then is, well, who are you? I mean, if you're going to ask them, who are you? I mean, you're claiming to be a judge. Fine. You think you're a judge? Produce your oath bond qualifications. Do it now. You have a legal obligation to do so. If you cannot produce your oath bond qualifications, you agree you vacate the bench, you perjure your oath, and you're a traitor. In which case, you need to be arrested because you've been impersonating a public official and you've been stealing the public funds. So, what have these lawyers done? What is the difference in how they operated to get the resolution that they wanted and how everybody else operates? Guess what? It all comes down to contract. You know how they've been swindling you all these years? It's all been contract, hasn't it? I mean, how do they know that they can come after you in court, and how do they know that the judge is going to find in their favor? It's very simple. The judge simply takes a silent judicial notice, not just of your social security number, but of the fact that you have a bank account. And by the virtue of the bank account, you agree you are a U.S. person and therefore are subject to the tax. Hello? They don't have to say this out loud. You simply take a silent judicial notice. So how can you fight fire with fire? I mean, they're using contracts against you, aren't they? So therefore, can you not also use contracts against them? What about the contracts they're already liable for? Take an oath of office. Hello? Excuse me, do they have any rights? No! They're public servants. Say goodbye to your rights, unless it's in the private. You're operating as a public, taking public funds. You don't have any rights. Now, as the creditor, hello? I mean, if somebody trespasses, commercial trespass, if somebody tries to steal your funds, if somebody falsely accuses you, what are you? You're no, you're not a victim. You're a victim if you let it happen. But what you really are is the creditor. Have you ever noticed that people post signs all over the property? They take down a street sign, they take down the number off their house, right? And they post signs everywhere. It says, posted, no trespass. They'll even take the black marker and black out the IMG. No trespass. That's a legal warning. What is it warning of? It's saying, you crossed the boundary, pal. You have injured me, and you are liable. That's what that means. Now, what's the missing ingredient? Anybody? You're the creditor. Exactly. And what does enforcement take? You are going to enforce it, not some judge. What does enforcement take? Huh?
Force.
Force. You know what? Commerce is warfare. Commerce is warfare. If you're not willing to prosecute your war, pack it up and go home, you're already a slave, whether you want to admit it or not. You are. You're beholden to somebody else. You're screwed. So if you're going to prosecute your claim, you better have an effective means to get what you want. And I'll tell you what you want. Item number one, forget money. There is no money. So what's the best thing to get from some scumbag criminal who's a vampire sucking blood from every one of your neighbors and friends? What's the best thing you can do? You discredit him. You expose him. You put him up to public ridicule, and you dispose of him. That's what's necessary. And the only way we can do this, people, unfortunately, the only way we can do this is not simply to get together to study and learn. Yeah, that's a great first step. The second step's more important. Take what you've learned and take action. And here's what I'd like everybody to challenge everybody to do here today. You've learned a lot today. the tools that you're getting on this CD are actually highly effective. The key, however, to making them effective is to follow through. To follow through. To follow. You don't give up. You keep coming. Now, wait. I'm working with some people right now who have very serious IRS issues. And one of them said to me very recently, I think I'll just quit. I need to get this behind me. I need to get on with my life. I said, why do you want to do that? He said, well, I'm tired. I need to make a living. In other words, I'm tired of all this rubbish. I said, well, excuse me, for the last few months you haven't really done anything. I've been doing all the work. What do you mean you're tired? All right? Was it a valid complaint? Absolutely. Why? It's an emotional drain, isn't it? Isn't it? Okay. How do we overcome that emotional drain? I don't know about you, but earning a living can be an emotional drain. I mean, hello?
Winning is an emotional uplift.
Okay. So the way you get over it is you say, hey, this is business. How many people have paid credit card bills for a period of time? Do you think twice about writing out the check, sticking it in the envelope or whatever? Hey, you do it every month. You don't think about it. It's business, whatever. Right? I got news for you. If you have all your ducks in a row, that's called planning, and you know where you're going and what you're going to do next, it's just business. And then you can take your emotions out of it, at least the part that drains you, and more importantly, when you know what you're doing and you have a plan and it's effective, what you just said applies. It's an emotional uplift like you won't believe. It suddenly gives you a reason for living. It suddenly makes you say, you know what? I'm worthwhile. I'm accomplishing something. I can be a role model that can show other people how to do what I'm doing. Because you know what? God made the world very inconvenient for one simple reason. It was to teach every single one of us to get up off of our asses and do something to overcome. He that overcometh will I make a pillar in the temple of my God, and he shall go no more out. That means we all get to go to heaven, but not until you overcome. That's why you're here. Go make it happen. Thank you.
One more. Hey, Jesse, how you doing?
Thank you, sir. Thank you. All right, how is everybody? All right. You gotta make it happen. Make it happen. And as RJ said, RJ McKee, you gotta use the key of faith. Key of faith and point everyone. The challenge is to use your use of the key of faith. Do me a big favor. Do yourself a big favor. Point them to the lake. Point them to the lake of fire. Tell them to go see Lucifer. All right? Okay, I got some books back here. I'm getting rid of my library. Fire sale, make offer. Some of them I'm giving away. All right. Law school. This is Richard Cornford's Helm School Society. Coming up May 6th through the 18th. It's a 2-week school. Helm School Society in Tampa. Location to be announced May 6th through the 18th. Okay, how many of you were at Richard Cornford's most recent seminar this past 2 weeks ago? Can I get a few comments? Bob, can I get a comment?
Absolutely fabulous.
Great. Comment. Over here. Comment.
You need to go.
Huh?
You need to go.
All right. Comment.
All I can say it was awesome. I wasn't prepared to give a comment, but
Right.
the information I got was invaluable.
Great.
One of the best 2 days.
Great. Randy, you asked a lot of questions over there at Richard Cornford. I saw you. Comment.
I was impressed.
Good. Somebody had a round table there on a Saturday night, right?
You did.
Who? Me? Okay. All right. Listen, you need a goal. You need to make plans. You need to roll up your sleeves and dig right in. You need to treat this like a very serious endeavor. You need to put some systems in place. You need to get some real grounding. Go to Richard Cornford's website. richardcornforth.com. richardcornforth.com. He is the man. He knows how to teach you what you need to know for yourself, so you won't have to rely on any lawyers, on any licensed or unlicensed people to help you or represent you. You won't have to do that. Go to richardcornforth.com. He is the man. He'll teach you what you need to know when it comes to law and the rules of law and how to use it, how to be well disposed to use it. No, it's not legal advice. It's not about legal advice. It's about freedom. The freedom of life, liberty, and property. That's what it's all about.
Sure.
Check it out. richardcornforth.com.
Ask him if he wants to.
Town School Society. The best investment of your time, talent, and treasury you can ever make. Any questions? Questions? Thank you.
Chris.
I'm going to have Marlon talk about the state courts. I think that's a bona fide issue that we need to address because I'm not familiar with it, and I'm certainly wanting to know.
A lot of people that have been thinking in terms of the IRS issues being in the federal court. Well, your issues are in the state court. Under Article 5, Section 20C3, the State Circuit Court has exclusive original jurisdiction in all cases involving the legality of a tax assessment. So if you ever are in the federal court, if they call you in the federal court, you can go there, but if you raise the issue of the tax assessment, that has to be addressed in the state court because the federal court can't have jurisdiction. If you look up exclusive jurisdiction in Black's Law Dictionary, you'll see that it's an issue that cannot be handled in any other form. It's exclusive to the court that has that exclusive jurisdiction. Federal court can't have jurisdiction. There's another issue why federal taxes cannot be addressed in the federal court. It's Title 28 USC Section 2201. That's the Declaratory Judgment Act. It says that the United States District Court can render declaratory judgment except in federal tax issues. Of course, there's exceptions to that. If you're in 501c3 organization, that's under 20 or 7428 of the Internal Revenue Code. And then there's a couple other things, but almost none of us are in those exceptions to the exception.
Say that code number again? Federal Declaratory
The
Judgment?
Declaratory Judgment Act is Title 28 USC Section 2201. So they can't render a declaratory judgment in the federal court if it's a federal tax issue in relation to you. So in order to kick that into gear, you have to say, I want a declaratory judgment in regard to all the issues relating to the federal tax assessment. Now everything is locked into the state court, and if they won't relinquish their jurisdiction to the state court and move it there voluntarily, you can then go to the state court and file a writ of habeas corpus, which costs $0. In the state, habeas corpus is free. It's a writ of right. And the writ of habeas corpus it's called writ of habeas corpus cum causa. That's a shortened name for writ of habeas corpus ad faciendum et recipiendum.
Oh, of course.
Anybody would have known that. But the state court, you can move the case and the parties from the court without jurisdiction to the court with jurisdiction to handle those issues. And once it's determined that there was no federal tax assessment because you were not in a legitimate subject to taxation, now there's nothing to bring back to the federal court for the federal court to take over the jurisdiction that they have. So everything stops there in the state court, and if they have gone to the point of filing a federal tax lien, now you've got a remedy in the state court under Florida Statute 713.21 subsection 4. That's for any lien perfected under this chapter, under chapter 713.
There's an example.
And criminal actions under 845 something or other. Filing false papers,
Oh, that's 843.0855. Okay.
Check out that example of the 2201.
Yeah, this is a petition for writ of habeas corpus, and it's filed in the United States District Court. Who's bringing the issue to the United States District Court?
Well, we're telling them that we want them to move it into state court. We want them to file a writ of habeas
You see,
corpus.
a writ of habeas corpus pulls the case. You go into the state court with your writ of habeas corpus.
What would we file then in the federal court?
You don't file in the federal court, the state court handles it.
We would ask, you said petition the federal court for a declaratory judgment about.
Yes, you just raised the issue in regard to declaratory judgment, and then you challenge the jurisdiction of the district court to render the declaratory judgment because of federal tax issues. That has to be handled in the state court. But you only mention that you need the declaratory judgment there. You don't ask them to bring it to the state court for the declaratory judgment unless you think that they might do it.
I'll tell them.
If you ask them, you let them know that it's in the state court, that's where the jurisdiction is, do you want to move it there to settle that issue? And I want to carry this, the lawsuit in the state a little further. The provision, your remedy in 713.21, subsection 4, is to get the lien canceled, or the liens canceled. However, that's only part of your remedy. You also have a remedy to get paid. That's in Florida Statute 713.31, subsection 2, paragraph B and C. And in
743?
712.31, subsection 2, B and C. Now, there's an interesting statement in paragraph 2, B, that says it is a complete defense simply to state that the lien is a fraudulent lien. Have you ever heard of making a simple statement like that and it's your complete, that's your complete defense? So that part is easy. The part that is hard is to give the judge to know that exclusive jurisdiction in the state court means exclusive jurisdiction in the state court. It lets you to know that.
How many?
There was one case where they allegedly moved the case file and then they allegedly moved it to the federal court. And
But if I've
it
got
sat
four,
there
that's
for
not even
about
as
2
much as I
years.
gotta pay my editor.
And
so I have to
this
look and
case
see
was still open there in the state court, and they
I
thought
mean, I
that
might
they
end up
should
refunding
see
everybody's
what they could
money.
do to close it, so they
If it's
sent
gonna
out
be a big
a
loss for me, I'll have to
paper
refund everybody's money.
to
That'll be
this
easier
lady,
than paying somebody
and
$300
saying
to do
that,
the editing.
that
And then,
we think
you
this
see what I'm
case
saying?
should
Yeah.
be closed,
I've
and
only
we're going
collected
to give me
$140
an
so far.
opportunity to come
I'm paying
to a
out
hearing.
$300.
if they don't believe that it should be closed. So she said, okay, I'm gonna go to that hearing. So she first proved that the state court had exclusive jurisdiction in the paper, requesting to go to the hearing, and she sent out, she went to the hearing, and the clerk tried to do everything she could to discourage her from being at that hearing, saying that, well, that case was removed to the federal court, or you should go to the federal court, or you should get an attorney, and just one thing after the other. She says, I'm just here to go to the hearing that they said they were going to hold. And she said, well, we're not going to have that hearing. That case is closed. You mean they closed the case before they have the hearing to determine whether it should be closed? And, well, I don't know. And so she says, now, if they're not going to hear it, I've got an order here. Just bring it to the judge so he can sign it saying that he doesn't have jurisdiction. Well, I don't know if he'll sign that. Well, I've got another one here saying that he has jurisdiction. He should sign one or the other. And I'm here to get one of these signed. And so she says, well, just a minute. She takes one paper in and goes and talks to the judge. And then she comes out after about 20 minutes and says, well, the judge won't sign this, but he did say that he's going to hold the hearing. So she waited her turn and finally got into the hearing. And when she went into the bar, the judge made the statement. He says, I've been in this business for over 30 years, and I have just now learned that the state court can handle these IRS cases. Finally got somebody to see that the jurisdiction was in that court. So she had to set another hearing to get the liens canceled. However, she had another part of her case. She wanted to be paid under 713.31 for the fraud. Under section 2C of 713.31, whatever portion of that lien that they can't prove, that's the portion they have to pay you. So since they didn't prove any of it, they had to pay her the whole thing, $115,000. Yes. I'm getting to that. As soon as she went in with that, after it was canceled and she went in for a hearing to get her $113,000, once she got there, the judge, apparently somebody got to him and said, you better not do that. You better rescind that order. He rescinded the order. However, I think that somebody kicked him off because it made him rescind something he thought he should do. So he spilled his guts in regard to what she had to do to get her case back on track. So he told her exactly how to do it. The federal law, Title 28 U.S.C. Section 2410, and then he gave her a copy of one page out of his private manual that nobody else has access to, but he's got it, the state judges have in their court, in their chambers, that you don't know about. But he copied a page out of that, and it described exactly how the service had to be done so that she'd be able to get it right. So it's like he turned on whoever it was that turned on him and saying, you got to undo that. So now we've gone in and gotten it perfected. However, they had a rotation of judges, and the new judge, he doesn't know the Dutch jurisdiction anymore. So he says, wait a minute, this case has been removed back in 2004. Well, jurisdiction was recognized back in here in 2006. So they got jurisdiction. How did they lose it 2 years before they got it? Well, see, those are issues that are, rhetorical question, of course. But what we're in the process, the next step is to go in and give the judge notice of the things that gives the state court exclusive jurisdiction. He alleges that they removed the case. The lien is still in the state court. That instrument that the case is about is still in the state court, so they didn't move it. And that's another reason why the state court has exclusive jurisdiction. There's a stare decisis holding in Princess Lida versus Thompson. That's a United States Supreme Court case. The site on that is 305 U.S. page 456. It's a 1939 case. And that says that Princess Lida versus Thompson. She's one, yes, sir. Did you get the site? Okay, there's another case that's in, that ruled on in Florida. It's the Meridian versus Suncoast case. And both of those cases support that if the court has possession of the property, then it's an in rem matter, and the court gains exclusive jurisdiction and can shield it from all forms, including federal. So, it's simple enough. Anybody that can read should be able to understand the jurisdiction. And anyway, that's what we have to overcome now. But I've been spread so thin in the last year or so that it takes time to just get to that, to settle it. But that should give you an idea that the remedy for you is in the state court. And under Article 1, Section 21, you have access to the state courts for the redress of injury. Filing that lien against you is an injury. Once they file it and cause that injury, all the administrative remedies are over. You don't have to worry about talking to anyone anymore because the injury has happened. They've perfected the issues to where now you can go and get the remedy. However, if you want to proceed to settle the issue so that the United States attorney doesn't try to remove it from the state court, settle it by a presumptive letter to the United States attorney to get him to admit, by not making a response, he will admit that the state court has exclusive jurisdiction and you can settle the different elements of the jurisdictional issues to him. He can't respond. The only thing he can be able to do is to admit you're correct because you're quoting the law. He can't say, no, that law is wrong. I'm going to be the legislature now and I'm going to change the law. He doesn't have that authority. So, anyway, your remedy for any IRS issue is in the state court. And if you think that the IRS is the one that you're supposed to talk to, a lot of people think, well, I got an IRS issue. This isn't an IRS issue because once they file a notice of federal tax lien, it says that it's in the interest of the United States. The IRS doesn't have any interest in it, so they're not a party of interest. Once you realize they're not a party of interest, you don't talk to them anymore. You talk to the one that does have an interest. That's the United States, and their attorney is the United States attorney. So you bring up your issues with the United States attorney. and get all those settled. Once you settle it with the one that speaks for the United States, it's over. If he can show you any truths that overcome your truths, then let him do that. But up until the time he does, it's going to be over. And you'll be able to settle it by this presumptive letter.
Marlon, remember that when people need to get information, once the IRS has started investigating, they can now go straight to the agent and demand the IMF and every other kind of document they want. They no longer have to do FOIA requests. I wasn't aware of this, but I saw the law and I posted it on my list the other day.
Well, that's in discovery.
Well, no, it's when they're starting to investigate, asking questions, and already to come to summons, all that means anything you want, you give them directly.
But once there's an investigation, there's an investigating number, and that's filed in the court. They can't investigate privately. They have to investigate in relation to some court case number of some type.
They're talking about the summons, that's what Schultz proved, right?
Yeah, but as soon as they get an investigating number, they always operate under a number. So just find out what number they're operating under. Then you automatically have a discovery, because they would like to impose upon you a duty to answer them, and you don't have to make up their case. If they have a case against you, they have to come up with all of the elements of the crime that's against you themselves. It isn't you that supplies them.
Are you telling me that if there's a criminal investigation, I can now say to the agent, I give them a discovery list?
No, I would say so. Because anytime there's an investigation, you need to know what it's about. And in discovery, discovery actually is a privilege. But whenever they make some claims against you, now the reciprocal issues. In fact, if they ask you for information, and you know the issues, now you can do exactly what they did in that case that they settled out there in California. You answer. You just say, give me a list of the things that you want to know. And then you answer it, and most of it will be irrelevant because it does not involve a legitimate subject of taxation. Now, once you answer it, then you can go back and get the reciprocal side, which you have a right to. That part isn't a privilege. You've got a right to the reciprocal discovery. And now they have to answer, and if they don't answer, you can set it up in a way that you make truthful statements, and if they can't overcome them, or if they don't rebut them, it's established as, all it is a presumption when you say it, but as soon as they fail to deny or fail to rebut, now it's the truth. Yeah, right. There's a lot of things that's at our disposal if we'll use them. But I like this. Once I realized that everything's in the state court, everything started making sense. And everything I looked at, I could see that the state court has jurisdiction. There's no question about it. So maybe that will be helpful to you in your future pursuit of resolving these issues.
One of the things that I wanted to say is about Richard Carnforth. I went to his meeting a couple years ago, and it was great. And also, one of the guys that jumped in and helped me at the last minute on February 14th, the day after, he was writing it up. He's the one that went through the 2-week course of Richard Carnforth and brought some excellent material that I was able to file. So Richard Carnforth's meeting is very much something to go to. Well, we're going to conclude. I'd like to thank you for everybody coming. And if there's any now, the